Okay, I'll call this case then. State of Wisconsin versus Caleb Anderson, 22 CF 2091. Here's by Attorney Lemkool. Defendant is here in person, along with attorneys LaPlante and Vale. We're on the court's calendar for a sentencing hearing today. Did both parties receive a copy of the PSI, Ms. Lemkool?
Yes, Your Honor.
Ms. LaPlante?
Yes, Your Honor, we did receive a copy of the PSI. We did review it with Caleb. We have no corrections to make.
Okay, and then there's this letter that I received. It looks like it might have come in just today. It's dated September 22nd, restitution summary. Did you get that, Ms. LaPlante?
You know, well, we did get a copy of that letter. It's the first time we've gotten any information regarding any restitution. What we don't have is any itemization as to how that number was achieved, so we are certainly requesting that information.
Okay. I don't have a problem giving you some time. I have some documents attached to mine supporting the number. Do you guys?
Do you have this, Gary?
That was not a part of the e-filing.
Well, then, the state is handing that to you now. I don't expect you to have an answer now, but at least now you have a place to start with the backup information.
Ms. Franken is, sorry, Your Honor, Ms. Franken's indicating it was e-filed yesterday. I don't know when it was pulled through, but.
Okay.
And they might want to check the e-filing because when I printed out, only the first page.
Okay. Well, it's worth for future reference checking that out, but the point is I'm going to give you a little bit of time.
Thank you.
With that, before I rule on restitution, I'll just hold that open. Having said that, though, I will turn to the state for a sentencing argument.
Thank you, Your Honor. I also just want to make sure there was a letter that was drafted by the family of the victim. That does appear to be dated today. Oh, this was also filed yesterday. Ms. Franken's correcting me. But did the parties receive that?
Yes.
I did not. So I'm going to need a minute to read it, but I can make a copy right here.
Okay. Well, and they're not speaking today, so this is in lieu of that.
Do you have it? Well, when I referenced a copy, Ms. Lemkool, I was hoping you could bring your copy.
Oh, yeah.
And I'll make one.
Sorry, sure. Yeah. That's it. Yeah. Okay. Then it's in there.
Okay, and if you could just give me a moment, I'm going to read this right now, and then we'll be ready to go. Okay, I've had a chance to read that then. The defense did get a copy of that? I thought you
Yes, Your Honor.
You did. Very good. And back to you, Ms. Lemkool.
Thank you, Your Honor. I just need a minute pulling this up. Gary.
So you have?
As the state indicated, Your Honor, we are in compliance with victims' rights. The family of the victim in this case has chosen to file a letter that is what had been noted as the victim impact statement. I also, too, had the opportunity to review that today. I had previously reviewed the pre-sentence investigative report prepared by Agent Jeannie Delane, and specifically the recommendation that they outlined. The state's recommendation in this case is, with the defendant having been convicted of first-degree intentional homicide, we are asking for a parole eligibility date in 60 years, 60 years. As conditions, we're asking for no contact with the victim's family in any manner, no possession of weapons, absolute sobriety, pay restitution to the court to the extent there is any. It appears that the defense may be asking for some time with respect to that. In response, we have no objection. We're asking for completion of any recommended treatment, including AODA, cognitive development, anger management, no possession of alcohol, drugs, or any drug paraphernalia, no association with known drug users or sellers, a DNA submission, and court costs. With respect to the Galleon factors, we're before the court on an incident that happened to our victim back on August 2nd of 2022. I mean, there are no words. This is a case for which this defendant had engaged in criminal conduct in essentially a horrific crime spree, starting with the attack on the young woman in Michigan, traveling over here to Green Bay after making contact with our victim, and extending on down to Alabama, where he took the life of another individual. The Galleon factors with respect to this defendant, the character of the offender, I think in light of everything that's happened here, the character is extremely dismal. I know this is not an individual who has much of any other prior history. That's what in part makes it so sad and so really unpredictable, and the unpredictable nature of what happened in this case that couldn't have been seen is exactly what victimizes people in our community when we have an individual who makes contact with somebody coming over here with ill intent and acting in some of the most horrific ways. The serious nature of the offense, I mean, first-degree intentional homicide, we can't really get more serious than that. The intentional, what gets looked at cases like this, we've got somebody facing life in prison, is whether or not he should be eligible for parole or what his sentence should be. He took the life of another, and as exhibited by the family in this case, who I can tell the court has been nothing but gracious with law enforcement, with our office, not spiteful, not vindictive, just incredibly sad and grief-stricken, mourning a member, somebody that, as they indicated here, we don't wish for any family to have to live through the range of emotions we experience that can test your faith, question mankind, or even the society we've become that would foster a person that would not value another man's life. All we have heard from the family is how P.E. was a good, upstanding citizen, somebody they loved, somebody they cared about, somebody that was taken from them in one of the most horrific ways. I think anything but a significant time of incarceration would diminish anything with respect to that. Besides the serious nature of this offense, the third Galleon factor, protection of the public. You have a man before you, in this case, that killed our victim, killed a human being. He's got a history of killing in another senseless case in Alabama, another individual. He had attacked a young, defenseless, random young girl in Michigan before this offense. I think the protection of the public in this case was somebody who took the crime spree and engaged in the criminal acts that he did on this date from August 1st of 22nd through the 2nd through the 3rd. I think scream for a significant sentence. The state does believe that the sentence that we are offering to the court is appropriate. We believe that the conditions that we have outlined are such that would attempt to assist this defendant in not only being held accountable, but learning what type of treatment needs are appropriate should he ever get out. I am aware with respect to the Alabama sentence that it does not appear. I do believe he's got life without parole. You never know in these cases, and I think when we started our case, some people said, you know, well, in Alabama, if he's already facing that, why would we be bringing him back here and fully prosecuting him? We have a different victim. We have a victim's family who deserves to know that this individual and this defendant is held accountable for what they did in the loss of their loved ones. But B, as we've learned with other cases, you never know what can happen to a sentence. You never know if there's a law change in Alabama. You never know if for some reason there would be a problem with that conviction or that sentence. So it was important in this case to make sure that Mr. Anderson was held accountable. We do believe what the state is offering meets all three Galleon factors that are before the court: protection of the public, serious nature, and the character of this offender. We are asking the court to adopt it. Thank you.
Thank you. Mr. Plant.
Your Honor, defense is in agreement with the recommendation of the PSI.
Anything else?
No, Your Honor.
Okay.
I do want the record to reflect that we did file a photograph of our victim. I think in these cases, when we're looking at cases, a case or a file has a number, sometimes it dehumanizes. Even the initials we use for protection and privacy with a victim dehumanize things in these cases. And we wanted to just make sure that the court had the ability to see who the victim is in this case and who this case is about.
Okay, I've got that. It's been marked as exhibit number. And I'm assuming the defense has seen that.
Yes.
Okay, then, Mr. Anderson, this is your opportunity to address me if there's anything on your mind you'd like to say before I pass sentence.
No, Your Honor.
Okay. Well, I need to consider the gravity of the offense, the character of the defendant, the need to protect the public, as well as other factors, including rehabilitative needs and punishment, and then craft a sentence in each case that's appropriate. In this case, there's some standard factors that a court considers when reflecting on someone's character. I consider their prior record, and when I look at the pre-sentence investigation report, page 5, Mr. Anderson doesn't have a lengthy prior record. It's a serious prior record, particularly as it relates to the Alabama charge. So I consider prior record. I consider the fact that he's now come in and admitted responsibility for his actions. I think that's a favorable character trait. I've looked at his educational background. It's like he was homeschooled and he's had some employment in the community, and I think the fact that people have employment in the community is a favorable character trait because it indicates a willingness to go out and earn your way in the world and not make anyone else support you. And so I think that's a favorable character trait. If my calculation is correct, the defendant is now in his mid-20s, 25 years old. So he's a young man, a lot of living left to do. I turn to the gravity of the offense, and you know, the state reflected on the fact that this is about as serious as it gets, and it's not necessarily just the end result. The way this unfolded, this kind of a crime is difficult to get your hands around. And it's difficult for our community to accept. And I reflect on the fact that according to the report, there were inordinate number of stab wounds. The report here said 51. I will take that report at its word. There's just a lot of them. There was graffiti around the area where this occurred. It was just a gruesome scene that law enforcement came upon. And when the community hears about that, and that this is something that happened in our town, I think it is concerning, and it goes to really to the gravity of the offense. Not that any death occurs in a good fashion, or that someone being killed happens in a way that's palatable, but when it happens like this, it just is very, very disturbing and troubling. And to think that it occurred by someone using a dating app, which so many people in our community use. That's a beneficial feature of technology that we have these days, that people can connect with others socially, romantically, their phones and apps, and to have this be the result really, I think, strikes fear into the community. And so the gravity of this offense really can't be overstated. The need to protect the public exists as well, because I reflected on the fact that the defendant has a limited prior record, and that's absolutely true. And so the notion that no one could see this coming might be an apt way to describe it. And that too is scary, when there's just things like this happen randomly by people that you wouldn't expect to have it come from. It makes you look around to your fellow members of the community, wondering if it could happen to you. And I think the public looks to the court for protection from things like this, and asks the court to do something about it. I take the task of sentencing these cases very seriously. There's certainly some rehabilitative issues that need to be addressed, and there's certainly a need for punishment. That the public needs to know that the justice system will come down seriously when things like this happen, and so that others can see the serious nature of the sentence and hopefully conform their conduct better and avoid this kind of experience in their life. But in any event, there's certainly a need for punishment in this case. The state is asking that the court make the defendant eligible for parole in 60 years. The defense is essentially suggesting that I adopt the recommendation of the pre-sentence investigation report, which means that there would be no possibility of parole. I'm satisfied when I consider all the factors I'm required to consider in this case, that I'm going to sentence the defendant to life in prison. I'm going to adopt the recommendation of the PSI writer. I'm not going to grant the possibility of parole, and it's based largely on just the events that have transpired in this case, and how it occurred, and what occurred, and the result, and the entirety of the circumstances surrounding it, I think, justify that conclusion. So that'll be the order of the court. Certainly, I'm hoping that the treatment that was outlined here today will be offered to the defendant in the prison system, and that he'll get some. so that he can find meaning in his life moving forward, but that's going to be the order of the court. Questions, clarifications?
I just wanted to make sure that no contact with the victim's family, and I see that here with a DNA sample.
I'll certainly enter some of the basic requirements. I'll order a DNA sample. I'm going to order court costs, $538. I'll hold open the restitution for a period of 30 days. If I don't hear any objection from the defense, the restitution will default to the $13,714.75. If, however, there is an objection, which is fine, within that 30 days, then a restitution hearing will be scheduled and a new amount can be entered. I think the rest of the conditions that are cited really go without saying, insofar as he'll be in incarceration, but no contact with the victims. And the programming is deemed appropriate by the institution. Any other questions, Ms. Lemkool?
No, Your Honor, thank you.
Questions, clarifications?
No, Your Honor.
Okay, very good. Then with that, the matter is concluded.
Thank you.